appreciated that when I was associate dean. And just as important, maybe more important, he is fun. Hal and I, it turns out, share a fondness for animals, and as a result, I've learned a great deal about Bernese mountain dogs. We share an appreciation for the same sort of humor that is perhaps not shared by everybody else, but that means we tell each other the same jokes over and over. We always enjoy them. And we also share a fondness for Paul, my co-group, which gives us the chance to spend even more time together. So it's been a privilege and a treat to work next door to him as well as with him. Among the many things I appreciate about Hal's scholarship is that its intellectual rigor is accompanied both by pragmatism and deep decency. He has served as a lawyer in the Department of Justice. I have too. We both share the feeling that that experience was a great privilege and a great joy. And I note that each of our panelists on this first panel have also engaged in significant public service as well. Hal's writing reflects his understanding of the challenges as well as the importance of the government officials. And these challenges include the everyday challenge of wielding power wisely, effectively, without abusing it. Challenges, for example, of balancing fundamental interests that are often in tension, for example, national security and military issues. So he knows very deeply that this work is not easy to do. And even so, he insists that we can and we should have very high expectations of those who do it, and is willing to show us a meaningful path for how we can achieve those high expectations. So I'm delighted we're going to be starting off with a terrific panel that's going to further explore some of these challenges. And I'll introduce our panelists in the order that they're going to speak. First up, immediately to my right, is Peter Shane, professor at the Ohio State School of Law. Prior to joining Ohio State, he was at Carnegie Mellon University's John Heinz III School of Public Policy and Management. He's also served on the faculty at the University of Iowa College of Law. He was dean at the University of Pittsburgh School of Law. And earlier, he served with Hal in the Office of Legal Counsel at the Department of Justice. Peter writes and teaches on administrative law with a specialty in separation of powers. Next will be David Posen, professor at Columbia Law School. Before entering academia full-time, he served as special advisor to the U.S. Departments of State, to the Departments of State's legal advisor, Al Cole. He clerked for Justice John Paul Stevens on the Supreme Court, and for Justice Merrick Garland on the U.S. Court of Appeals for the D.C. Circuit, and he served as special assistant to Senator Ted Kennedy on the Senate Judiciary Committee. David now teaches and writes in the areas of constitutional law, information law and policy, international and foreign affairs law, and national security law. Then finally will be Kathleen Clark from the Washington University School of Law in St. Louis. She recently served as special counsel to the Attorney General of the District of Columbia. She's also taught at the University of Michigan and Cornell Law Schools. She clerked for Judge Harold Green in the U.S. District Court for the District of Columbia, and also served as counsel to the U.S. Senate Judiciary Committee. And at this point, Kathleen is teaching and writing about national security law, ethics, and government corruption. So our plan is that each will speak for about 15 minutes, and then I'll invite each of them to offer any comments on the other presentations if they so choose, and then we'll open it up for a full discussion. Thanks again.
Thank you, Helen. It's great to be here. I want to thank Melissa and the Center for having us, and Reed and his team of stalwarts for doing so much of the logistical work for us. It's great to be here at a conference celebrating Hal. It is true, we've known each other and worked together since about 1979. I would like to say even then he was older than I am. But these are the days in which Hal was still running marathons, and I can remember the envy I felt when we would go to the Justice Department cafeteria together, and he would have, there would be a wide selection of pies, and he would pick 2 for dessert that he would carry out, and he could say, well, this is just balanced nutrition, just preparing for a marathon. Couldn't get away with that myself. The other,
I'm sorry.
the serious reason, or yet more serious reason why I'm glad to be here is I think, and I've always attributed this, Hal, to your Western roots, but I think Hal was born without the self-promotion gene. And it's nice to know, as this conference suggests, that sometimes it is true that just good character and good work occasionally does speak for itself. So it's really great to be here. The paper that I prepared for this definitely resonates in some of the themes that Hal treats in Untrodden Ground, but is probably more inspired in a way by the previous book, Bad Advice, which really focuses on what the lawyer's role is in advancing rule of law values under very high stakes controversies and challenges. Now, the Bush 43 administration, which was very much the focus of that work, had as among its conspicuous features a willingness to advance quite aggressive claims for exclusive presidential authority under Article 2, claims of authority that purported to be beyond Congress's power to regulate. Now, many of these were relatively familiar claims that other presidents had made about the president's role in foreign and military affairs, but of course many other claims, particularly in his notorious signing statements, were novel, sometimes startling. My personal favorite was the claim that the commander-in-chief power precludes Congress from telling the president how many members of the military can be assigned to the Pentagon Office of Congressional Liaison. Apparently, the war on Congress was considered part of the commander-in-chief power. Now, in seeming reaction to this, and perhaps also, but I think also reflecting a genuine philosophical difference, the Obama administration has been slower to advance novel Article 2 claims. There's been a far, far smaller use of the signing statement as a technique for advancing these claims. And what's been remarkable in a way, and you can see this even in the administration's treatment of an important question that Hal discusses in Untrodden Ground, which was the killing of Anwar al-Awlaki. I mean, one might have expected that had happened under the Bush administration, for the administration to say, you know, U.S. citizen, yes, that's true, but if you are outside the territorial United States and you take up arms against the United States, you've given up the right to due process. And the Obama administration didn't say that. They said, we agree, he continues to have rights to due process, we're constrained by the Constitution, and they offered a defense for, you know, why their decision-making still complied. Now, that doesn't mean that the administration, the Obama administration, has stinted on the aggressive use of executive power, because Congress actually amended the Foreign Intelligence Surveillance Act to give what was then the Bush administration the authority it had been arguing for. The Obama administration has not had to rely on as much creative argument to continue some of the same programs, but as the deferred action programs that have been instituted by the Department of Homeland Security suggest, the president's willing to oversee executive action that's pretty ambitious. The most conspicuous, I suppose, the most conspicuous controversy about this, to my mind, was the decision to remain in Libya beyond the 60-day deadline set in the War Powers Resolution, which was based on an argument about the meaning of hostilities that is certainly subject to criticism. So this raises the question, should citizens who care about the rule of law take any solace from an administration's decision to base its unilateral executive action or its aggressive executive action on statute rather than on the Constitution, especially when the statutory reading is strained? As I said, the reading of hostilities in the War Powers Resolution is, you know, statutory purposivism with a vengeance. It's certainly not the administration's reading of hostilities probably does not correspond to most conventional understanding of the word. But the argument that I want to make in the paper is, yes, that we are actually better off from a rule of law point of view when an administration, even an ambitious administration, stakes its ground on a statutory rather than a constitutional basis. And what my paper proposes is recognizing a distinct strategy of statutory interpretation that I call the statutory stretch. It's characterized when the administration is proposing a reading of statutory law that Congress would almost always consider a surprising reading. It's offered in an area where presidents have at least a colorable argument as well of inherent Article II authority that might or might not overlap with the powers of Congress. But the interpretation at issue is rhetorically positioned as a sincere effort at statutory compliance. It doesn't rely on the constitutional avoidance canon in order to support its surprising statutory reading. So, right, so I should be clear also what I'm not talking about. I suppose for an ardent textualist, any purpose of this reading of the statute is a statutory stretch. I'm not an ardent textualist, so that's not my position. I'm talking about, I'm willing. I personally regard certain interpretations as perfectly sound and persuasive, relying on traditional tools of statutory interpretation that go beyond plain meaning. But I also don't mean to include constitutional argument that is just veiled as statutory argument depending on the constitutional avoidance canon. So to take an infamous example, the so-called torture memo that I think Hal mentioned last night gave an implausibly narrow reading to the kinds of physical harm that would count as torture, but they were really framed by the proposition that if the statute, if the War Crimes Act actually purported to limit the president's authority to approve any interrogation techniques he wanted, then it would violate Article II. I think in Bad Advice, Hal calls this technique firing the cannon, with one end in the middle, and is deeply critical in that book of the Bush administration's overeager use of that technique. What I'm trying to capture is a technique that's deployed when the president is committed to a line of action that's not patently authorized either by Article II or by statute, but there is a non-absurd argument that can be made for either. The president offers the statutory argument without relying on the avoidance canon. And examples would include, for example, the Clinton administration's argument for the Kosovo operation being authorized by appropriation statutes, President Bush's reliance on the authorization to use military force for authority under the Foreign Intelligence Surveillance Act, although the actual written defense of that did have a little Article II mixed in. President Obama's insisting that the Libya engagement was consistent with the War Powers Resolution, and I suppose the shared interpretation of the USA Patriot Act before its most recent amendments, in which both the Bush and Obama administrations defended the use of Section 215 to go after telephone records under a kind of needle in the haystack theory of what counts as relevance under the statute. So, in arguing that the statutory argument is preferable from a rule of law point of view, I'm building on other things I've written that argue for a conception of the rule of law in the administrative state that embodies kind of 5 central premises surrounding the exercise of government power. The insistence that power be exercised pursuant to politically legitimate authorization, the observance of human rights, accountability to legal constraint, the expectation of legal justification, and the availability of remedies for government-imposed injury. And this conception of the rule of law, which is not just law by rules, I should say, is very much dependent on institutional norms, expectations, and routine behaviors or conventions, not just compliance with written text. So a president that avoids Article II claims in favor of statutory claims, I argue, shows respect for the accountability principle by implicitly recognizing Congress's entitlement to set constraints on executive action and the president's at least theoretical willingness to be bound by them. Why this is okay, I think, is because, or I should say why it's preferable, is that the attitude of an administration towards statutory interpretation, I think, does help shape an institutional psychology within the administration, kind of organizational psychology that affects behavior. That if a president and his or her top lawyers are willing to forego arguments that the president has some unbounded exclusive authority under Article 2 that's not accountable to Congress at all, that does help bolster a kind of ethos of constraint that is likely to lead the administration to avoid as many arbitrary or ill-considered ventures as an administration might pursue if its ethos was, we can basically do whatever we want just by saying Article 2 allows it. An executive branch that regards itself as bound by statutes, even if loosely, I think will be more attentive to factors other than its contemporary political preferences in deciding whether its actions are legitimate. Now, in a sense, this is counterintuitive. The statutory stretch might seem like it signals a kind of disrespect for law. It runs the risk of crying wolf if every statute turns out to be utterly surprising in its import for the administration. Then it may cast doubt on the credibility of almost anything the administration says about its legal position. Like Article 2 arguments based on broad statutory readings can provide institutional precedents that other presidents will follow in the manner that Hal described last night. In a way, it lets Congress off the hook for difficult problems. If you're willing to read into a statute what Congress didn't clearly put there, then Congress realizes it may not actually have to make a hard choice in rewriting the law. And it makes legislative drafting more complex if Congress really wants to be clear in its constraint. But I think the insult to the rule of law problem can be offset if the technique is used rarely. If the strategy is used rarely, it ought to have very little bearing on an administration's overall lawyering in run-of-the-mill contexts, even when the administration in other contexts is also of a non-textualist persuasion. And there's a built-in limitation on this strategy because if the administration has good lawyers, they won't put up with it too often. They'll do it in a few cases where they understand the president's sense of urgency. They won't be willing to make it routine. The other thing that limits the possibility of undermining the rule of law is if it goes on transparently. That is, if an administration, as in the case of the War Powers Resolution, is taking this kind of aggressive interpretation, but it's willing to do so publicly and take whatever lumps may follow in the scholarly or media or political communities, that also is a constraining factor on its overuse. It provides an institutional precedent, maybe for presidential ambition. Libya, of course, is now an example that other presidents may use. They want to keep U.S. troops committed to some place for longer than 60 days. But it does at least keep open the invitation for congressional involvement, which Article 2 arguments do not. Congress, by the way, does know how to prevent a statutory stretch when it wants to. President Clinton did rely on appropriations measures for saying that the U.S. initiative in Kosovo was authorized. He did this in the face of the War Powers Resolution saying that appropriations would not be relied on as authorization. I won't go through the whole argument, but when President Obama successfully secured from Congress appropriations to support the action in Syria, that appropriation statute said, by the way, this statute is not authority for being in Syria under the War Powers Resolution. So Congress, after it elects a speaker, can probably again figure out how to write laws if it wants to. So how does this position the lawyer? The lawyer obviously still cannot make arguments that are utterly indefensible. It's important that the lawyer not hide the legal vulnerabilities that attend the statutory stretch from his or her client, that is the president. It shouldn't be used to justify what are potentially grievous wrongs or abuses. Even when presidents have strong grounds for claiming executive privilege, it's conventional White House understanding that executive privilege is not used to cover up abuse or corruption, and the statutory stretch should not be used to cover up abuse or corruption either. And on that ground, I would say, by the way, that Libya is not as bad as the torture memo. In making this argument, I'm really comparing two possible states of affairs. One in which a president uses the statutory stretch, and one in which the president asserts a constitutional power. Now, of course, when the president sees that his or her authority is cloudy, there's always the third option of not proceeding. But presidents don't always regard doing nothing as an available option in the interest of the public. So the bottom line is, in these circumstances, if the statutory stretch is used rarely, transparently, and under genuinely urgent conditions that work no harm to individual liberty or human rights, it is better for the rule of law than asserting aggressive claims for executive power under Article 2. Thank you.
Hi. So my role is to, on this panel, is to respond to Peter's provocative article. But before I do, I just want to say how honored I am to be here at a conference among such distinguished company and honoring Hal Brough. I have to say I've been feeling like a bit of an interloper because alone, I think, among the panelists, I do not have a pre-existing relationship with Hal. I just met him last night. But then I reflected and thought that maybe there is something appropriate about someone like me being here because such an important part of Hal's legacy has been his impact on people he's never met through his writing, through the page. And I count myself very much in that category. So consider me a representative from the Hal Brough diaspora, or fan club from afar. And hearing Hal speak last night, again for the first time, I also just want to say how struck I was by the congruence between the work as I read it and the man, the author, and his subject. There's an important theme in Untrodden Ground of presidential character. It's already been referred to by Helen and Peter, and also judgment, something that we might call judgment. Not reducible to any formula or any grand theory of interpretation. Hal emphasizes this personal, even psychological dimension to being a good steward of the Constitution. And what struck me is how the book itself models the very virtues that it extols in presidential interpretation. It has, therefore, this kind of mimetic quality. The analysis itself exudes wisdom, decency, erudition, and good sense, and therefore not only illuminates for you how you might think about presidential interpretation, it actually shows you how it might be done in an attractive manner. So just one of the many qualities that makes the work remarkable, I think, is the sense in which Hal is modeling for you the very subject. Okay, Peter's a different story. I don't really believe that, but I will raise some questions about the statutory stretch. Okay, so the descriptive claim, as Peter's just told you of the paper, is the basic descriptive claim is that the statutory stretch is an important phenomenon worthy of recognition and study on its own terms. It's a distinctive phenomenon. I think it's an important contribution just in itself for Peter to identify the statutory stretch as a unit of analysis. Hal's book, I should say, does show that statutory stretch has an old pedigree. It's been with us for a long time. But I think it's right that it's taken a starker form in recent years, particularly in the juxtaposition between the Bush administration and the Obama administration. So as Peter says, the Bush administration raised hackles in the legal community by making what executive branch lawyers like to call naked Article 2 claims of authority. That is, Article 2 alone, without any reference to statutory authorization, allows us to do this or that. The Obama administration, by contrast, has avoided such claims. I just want to note in passing, there's a kind of irony or perversity, I think, that juxtaposition illuminates about the relationship between something like zealotry and sincerity in executive branch lawyering. If you sincerely believe extreme legal positions about Article 2 power, then you don't have to stretch, right? You don't have to get into the ambivalent position of making arguments you know to be somewhat strained in how to interpret a statute, because you can sincerely lead with your Article 2 move. So to borrow from Yates, the worst executive branch lawyers are full of passionate intensity, we might say, in that they never even have to get to statutory analysis. Okay, I think actually Peter and Hal, to de-polemicize that comment, would tend to agree with that. Okay, but now we don't have any more naked Article 2 claims. Instead, we have these stretches, and the question that raises whether the new emperor, the new approach, has any clothes either. Are stretches better for the rule of law? So Peter catalogs a number of possible rule of law harms from statutory stretching, which I won't recapitulate here. I'll just note that I find especially compelling a point he made in his talk about the potential endogeneity of this stretching and the lawmaking process. When presidential interpreters do a lot of this stretching, it raises the cost of lawmaking for Congress, knowing that their handiwork is subject to these potentially strained interpretations, which just reinforces some of the pathologies that make lawmaking so hard today in the first place. So the way in which stretching can get baked into the legislative process is very problematic, I think. Okay, but then the paper takes this somewhat surprising turn, and it ends up offering a qualified defense of the statutory stretch, and that's what I want to focus on. At least when there is transparency, as Peter says, and when the stretch is used cautiously, rarely, then Peter suggests we might look on it more favorably. There is a lurking baseline question, as Peter ended with, in the whole analysis, which is the relevant baseline or comparator no presidential action, or is it the president doing the exact same thing, making a naked Article 2 argument? Peter ends up basically assuming that it's the latter. Presidents in these cases are going to do something, so the real question is whether they're going to do it just on Article 2 grounds or on statutory grounds. I think that's probably fair, historically fair, descriptively fair, but we might question whether that's the appropriate baseline for normative analysis. Okay, but I want to suggest beyond the factors that Peter lays out, that there are actually many other factors that should bear on our thinking about the legitimacy of any given stretch, and whether or not it serves rule of law values. Just like stretching, the actual practice that is the metaphor that drives Peter's paper, there are many different types, and some are good for the body or good for the body politic, but some are and some are not. And I think it goes beyond rareness and transparency. Okay, so let me start with transparency. I would add to, and now I'm going to just talk about factors that I think bear on the legitimacy of stretching. And that might help us divide the category of stretching up into subcategories that enable sharper critical analysis. So in addition to transparency, I think something like salience or intelligibility matters a great deal. It may be the case that the executive branch is forthcoming about its reading of a statute and therefore satisfies the formal prerequisites of transparency. It's not hiding what it's doing, it publishes it in some way or publicizes it in some way. But nonetheless, it's actually hard for the American public or the media to register what has happened. And that might be the case because it's a highly technocratic situation or a highly complex statutory scheme. One ironic rule of law virtue of naked Article 2 arguments is that they're very clear on their face about what's happening. It's very simple and intelligible, even to an ordinary citizen, what the basis for claimed authority is. In contrast, I think some problematic stretches can hide, not by being, not literally hide as in we won't tell about what we're doing, but hide instead behind a cloud of statutory density. I think this may characterize some of what's happened with the Affordable Care Act. Some of the dubious readings of the Affordable Care Act, which I very much support as a citizen, I think haven't gotten much traction in the broader public as potential rule of law problems, in part because it's just difficult to penetrate the thicket of that statute. and for it to register with the public. A second factor beyond salience or intelligibility of the stretch that I think matters is whether, and now I'm again going to use the example of the ACA, whether the stretch might itself serve rule of law values by enabling a complex statutory scheme to function. One additional factor I think makes the ACA examples hard is you have Congress having enacted this major framework statute for healthcare. As is inevitable with such a big statutory program, glitches reveal themselves over time, and there are things that you would like to see work pure. But Congress having changed in its partisan complexion and our politics being what they are, that's not going to happen through the normal legislative process. And so you see the executive branch, at least in some cases, arguably perfecting Congress's own handiwork, bringing it up to date and making it workable. This doesn't necessarily characterize all the ACA moves, but I think at least some of them, through these statutory stretches. And there I think we have rule of law values on both sides of the ledger. On the one hand, you have the strained interpretation, which is on its face problematic for the rule of law. But on the other hand, you have the enabling of a statute that's already on the books to work in what seems to be the manner it was originally intended. So I think, at least in cases of updating against the backdrop of congressional gridlock, updating the statute, there too we might look more sympathetically on the stretch. A third factor is, and this relates to some of my own work, which just puts the previous point in more general terms, is when there's something like a self-help justification available. I think there too we might be more sympathetic to statutory stretches. By that I mean in situations where Congress is seen to have acted in a constitutionally bad manner. And of course that puts a lot of pressure on what that means, and we might have different views. But if the President has a plausible theory of Congress acting in a constitutionally wrongful manner, that the President might get more leeway in interpreting statutes is, I think, a plausible way to think about things. There too, the ACA might be invoked. The levels of obstructionism that exist in the current Congress are such that a plausible argument can be made that there's a separation of powers offense, just in the maximalist nature of that obstruction. Yes, separation of powers was always meant to cause friction and slow down the lawmaking process, but it was also meant to enable a workable government. And Obama could plausibly claim that the bad actions of Congress in not even being willing to negotiate in good faith with him have given him greater discretion interpretively. Okay, I can't bear out that whole claim here, I've written about it, but I think that too might bear on the analysis. A fourth factor might be something like congressional acquiescence or approval. I would feel better about a stretch if there are contemporaneous indicators that Congress was okay with it. That raises all the usual questions about how do you gauge congressional acquiescence. The executive branch likes to claim it rather promiscuously. But at least in theory, I think it's plausible that contemporaneous congressional ratification should make us feel better from a rule of law perspective. Fifth, and this Peter does get at this, but doesn't really draw it out as a standalone factor, is just the internal plausibility of the stretch, or the linguistic plausibility of the stretch. I think Peter agrees with this, but we would feel differently, I think, about a statutory stretch that a reasonable, objective reader of the text could think flies versus one that is just so outlandish as to mock Congress's handiwork. Six, another factor would be something about whether the stretch itself has internal limits baked into it. So what I mean by this is that some of the stretches I've seen the Obama administration make seem, at least on my reading, to self-consciously try to limit their own precedential significance by putting in a lot of circumstantial factors that limit the way in which they can be evoked in the future. So the war powers situation in Libya, which Peter cites as the most egregious stretch the Obama administration has made, where bombs are being dropped past 60 days in Libya, including by US drones as part of the NATO coalition. The statute says if hostilities are ongoing past 60 days, you need congressional approval, you have to get out. The Obama administration says no hostilities for various reasons. in the testimony introducing that stretch, interpretation of the statute, the Obama administration lays out this multi-factor test about how don't think this is just a general theory that allows anything to happen as long as drones are being used, and we won't call it hostilities. Rather, there's some very discrete circumstances, probably unlikely ever to be replicated, by the way, that make this applicable in this situation, including Arab League support for this intervention, UN Security Council authorization for NATO's actions. Both of those things are rarely combined, and other factors. So there's this sense in which the stretch was trying to limit its own precedential significance, which I think does serve a rule of law value, even if raises other problems. Seven, and I'm coming to the close here, is what Peter says. He's not talking about situations where a constitutional avoidance argument is made, but I think it matters whether it could be made. And there too, the War Powers Resolution may be significant. The Obama administration hasn't taken this view of the War Powers Resolution, but if you sincerely thought that it's dubious as a constitutional matter whether Congress could force the executive branch out after 60 days, not my own view, but many take that view. I do think that would actually help the case for stretching, even if the avoidance argument wasn't explicitly proffered. And by the way, the avoidance argument cannot be proffered if the stretch is significantly implausible in textual terms. You can only make an avoidance argument if it is actually plausible the text will be read in a certain way, at least on most understandings of the avoidance canon. So those factors interrelate. Finally, and I think kind of most obviously and banally, is judicial review available? I feel better about stretching when judges can evaluate it and smack it down if they think it goes too far. And that's one reason I think we might be worried about the war power situation, is that judicial review was not going to be available because of various justiciability barriers. So again, it's not. I think it's not just transparency that matters in thinking about the legitimacy of stretch, but also it's the ability of that transparency to enable meaningful checks. Judicial review in our age of congressional gridlock being the most important. Okay, so add this all up, and I just think it's very complicated to think about when and under what circumstances stretch is going to serve rule of law values or not, and that Peter's provocative and very helpful thesis might be further elaborated in those ways. But I'll end on a kind of cautionary note, which is that Peter himself ends the paper with an invocation of the idea of the second best. He says, okay, no one loves stretches. Any lawyers can be a little worried about, I mean, the term is meant to make us anxious. But we might think about them as a second best vindication of rule of law values. That's Peter's phrase in the conclusion. And I think what that perfectly tees up is the theory of the second best, which, as you may know, should make us worry that, as with all such claims, when you are trying to approximate a certain ideal, but you can't, in this case, the rule of law ideal of perfectly faithful readings of statutes, that's not going to happen in the world we live in. And what you do is you just kind of deviate on one dimension, but hold everything else constant. The concern is that can lead us further away from the ideal equilibrium than if you actually did something very different altogether. So the concern is that stretching actually isn't the second best approximation of perfect interpretive fidelity, but rather leads us to some darker places. And I think an obvious foil here might be the work of David Deisenhouse. David Deisenhouse is a Canadian legal theorist who writes about what he calls gray holes. And his basic claim is that black holes, legal black holes, are situations where there's not even the pretense of rule of law. The executive claims unconstrained discretion to do whatever it wants to do in a given space. Those are obviously concerning from a rule of law perspective. But Deisenhouse somewhat paradoxically argues that gray holes are actually more concerning to the rule of law than black holes. Gray holes, he says, are situations where there's the patina of legality. The executive makes a show of seeming to be constrained, but in reality, the legal constraints are so thin that there's no, that constraint is basically paper thin. And I think the stretch tees up the Deisenhouse critique and concern that actually this is worse than naked Article 2 arguments, which at least trigger on their face are a kind of pushback. Okay, I won't elaborate that further, but I think that would be a foil to take on if you want to really hammer home the claim. And I'm going to end on this note, which is just that there may be a kind of irony in the piece that we might think about. And that is that Peter and Hal both suggest in their work, and one important contribution of both of their work as I read it, is the significance of what we might call soft constraints on presidential interpretation. Even apart from judicial review and those kinds of hard constraints, they both emphasize the importance of professional, cultural, and reputational effects on aggressive presidential action. Which means that the criticisms offered by people like us in this room might, at least on the margins, have some impact on how executive branch lawyers think about their work, given the efficacy of these soft constraints. So then the irony I want to pose, the question is this: is this paper itself participating in the, not just observing, but participating in the very legitimation of stretching that it analyzes synthetically?
So I also want to thank Hal for your scholarship, and Melissa and Reed and the students who have put together this lovely conference. I also want to count myself among the Halbrough diaspora. I was a member of that diaspora before I ever met you. And I hadn't really thought of it, but I now realize I'm one of many. This morning, I want to talk about the role of whistleblowers in the constitutional conversation, and the implications of Hal's scholarship the implications of his scholarship for whistleblowers' role. But first, let me describe what I mean by constitutional conversation. I'm not talking about a conversation about the Constitution. We're having that kind of conversation this morning. But instead, I'm talking about a conversation between the executive and the legislative branches about how the government is acting and how it should be acting. I'm calling it, for the moment, a conversation, but you could also call it a dialogue or a dynamic or a dance, the interaction between the legislative and the executive branches on these issues. The conversation doesn't consist just of the words being exchanged, but also includes the taking of positions, legal arguments about those positions, and legislative enactments. So Congress puts pressure on the executive to conform to Congress's view by holding hearings, by enacting appropriations controls, by limiting the confirmation of executive branch nominees, among other mechanisms. And I would include all of that in the constitutional conversation. The conversation between the two political branches, the terms of which are set out in outline form in the Constitution's division of authorities found in Articles 1 and 2 in particular. So, and I want to acknowledge, first of all, that I think Hal and Peter have been pioneers in describing this conversation, describing the processes of interaction between the two political branches. They have put front and center the process itself, that dynamic interaction between the branches. And I think quite insightfully, their focus isn't just on the endpoint of the interaction, but on the process itself, including the legal arguments that are made by both sides of the argument. Legal arguments that are found in letters and memoranda that are exchanged between the two branches well before there are any court decisions on the particular matter. And so when Hal and Peter discuss and analyze separation of powers controversy, I think what is, to me, most remarkable is that they're not just describing a static endpoint, explicating which legal argument arguably prevailed in that encounter, but instead really do focus on the conversation between the executive branch and Congress, with the exchanges of letters and memoranda, and the pressure being put being exerted on both sides, such as through the confirmation process and appropriations law. And what I think is just an enormously important contribution is the way they describe the mixed legal and political dynamic of these battles between the two branches. And they show how these political players invoke legal constitutional arguments, as I say, long before any judge ever sees these arguments, and in contexts where judges will never see or evaluate these judgments. And so I just want to say that I remember when I was in law school, it was a bit of a revelation when my constitutional law teacher, Akil Amar, suggested that it wasn't just courts that were evaluating constitutional arguments, but I think in your scholarship I really see that concretely. Now, Howe makes a powerful argument that legitimacy, the legality of executive action, depends on the executive's participation in a constitutional conversation with Congress. And in your talk last night, you said that interpretation is a reciprocal process between presidents and ourselves, and that it's important that Congress can have the last word on the exercise of presidential power. To the degree that the executive branch keeps Congress in the dark about the exercise of that power and the justifications for it, for example, failing to disclose its unanticipated interpretations of statutes, it seems to me that the executive's claim of legitimacy is lessened. And this is where whistleblowers come into the constitutional conversation, it seems to me. I would argue that executive branch defiance of Congress, or even statutory stretches as Peter describes them, can be considered a legitimate part of the constitutional order only if the fact of such defiance is shared with Congress, if not shared with the people at large. And to the degree that you emphasize, Peter, the need for transparency, I think this is really key. But to put it in Howe's language, how can Congress have the last word on the interpretation of a statute if the executive branch's surprising interpretation of that statute is never shared with the entirety of Congress? And a lovely example that's already been alluded to this morning is the executive branches and the FISA court's secret interpretation of Section 215 of the USA Patriot Act, that it authorizes the government to collect information about every single phone call that every single one of us has made. How can Congress have the last word about the interpretation of Section 215 if most members of Congress never find out that that's how the executive branch interprets the statute? And in this kind of situation, whistleblowers obviously play a key role, or can play a key role, in ensuring that Congress has the opportunity to have a last word, which frankly to have a word in edgewise. Hal and Peter's focus on the process helps us see whistleblowers in this institutional, structural frame rather than in the frame of individual or expressive rights. I think when most Americans think about whistleblowers in the popular understanding and news accounts, we often focus on the individual whistleblower, his or her personality, his motivations, rather than on the alleged wrongdoing that the whistleblower is disclosing or what role that disclosure may have in our governmental processes. And when we discuss the law of whistleblowing, I think we tend to frame the discussion in individual terms, whether or not the whistleblower has a legal right to express himself in this particular way, to disclose this information to this audience. The focus is on sort of individual expression and individual rights, by and large. Now, this may be due to the primacy of our First Amendment, the naturalness that we would focus on individual and expression. And it may be due to the fact that a lot of the law of whistleblowing arises in cases where individuals are asserting their legal rights. But in other countries, the primary frame, I think, is a bit different. And instead, the law of whistleblower protection is referred to as the law of public interest disclosures, which changes the emphasis from individualistic expression to whether or not the disclosure is furthering a public good, is for the good of the public. So the focus is whether the disclosure serves the public interest, what information was disclosed and the manner in which it was disclosed. So the United Kingdom's Public Interest Disclosure Act, for example, gives broader protection to whistleblowers who disclose to designated governmental regulators rather than making a disclosure to the press. So the scholarship in the separation of powers law book, casebook of Hal and Peter, I think can help us focus on the constitutional role that whistleblowers can play. And examining the role of whistleblowers in our constitutional order in addressing separation of powers controversies, I think could be a sort of a significant shift, or can be a significant shift. And I'll say that I think that whistleblowers come into play in two distinct ways. One of them I've already referred to. On specific occasions, whistleblowers provide Congress with information about particular executive actions that Congress might object to. And we could see the Section 215 disclosure, the first disclosure of Edward Snowden in this light. It was made to the public, but the public in this sense includes Congress, providing Congress with the information about how the executive branch and the secret FISA court had interpreted Section 215. But there's a second way in which whistleblowers come into play, and I think Louis Fisher has written extensively about this, and that is that the battle over codifying whistleblower legal rights, the legal right to share information with Congress or others, is an example of the sort of constitutional conversation that the two of you have described. Because you have Congress, over the course of about 40 years, gradually increasing the legal rights of whistleblowers, and at the very same time you'll have executive branch assertions that the president has the authority, basically under Article 2, to prevent executive branch employees from sharing certain information with Congress. That's part of the executive power. So in the battles over the enactment of whistleblower legislation itself, you see the constitutional conversation going on, perhaps at an impasse, in a sense, as often happens with these rhetorical battles between Congress and the executive. And so I think that your scholarship, the scholarship of Hal and Peter, really help frame the role of whistleblowers and the way to think about whistleblowers in a way that is, it's not, I mean, I'm not the, as I say, Louis Fisher has talked a lot about this, and it's not the first person to address this, but I think it can help anchor the conversation in ways that haven't really received sufficient attention. So, you know, whether this was your intention or not, wittingly or unwittingly, I think that you set out a justification for encouraging whistleblowers to ensure that Congress has the information Congress needs to fully participate in this constitutional conversation. And I want to just drop a very speculative note at the end, which is I'm wondering whether this statutory stretch in particular, and the need for transparency on that, could set out a kind of justification for construing narrowly the attorney-client privilege for the executive branch, where legal advice, where lawyers are giving legal advice to the executive branch on making such a statutory stretch, that I'll acknowledge to you, I haven't thought this through, but it seems to me that that might be something worth exploring, that the justification for the secrecy in attorney-client communications for the privilege arguably is lessened where this other party, Congress, has a kind of right, somewhat inchoate right to information about the legal interpretation that executive branch officers are giving to statutes. So anyway, I really enjoyed your paper and of course housework, so I look forward to a different kind of conversation the rest of this morning.
already engaged each other's work quite a bit, but we're going to open it up to the full group. Any remarks, further remarks by any of you on what you've heard from the others? I'll start with you, Peter.
Sure. First of all, I'm sort of laughing to myself because Dave sort of prepared me to think that I was going to have this kind of full-fledged assault. And I find his treatment of the thesis and his elaboration of it mostly sympathetic and certainly very helpful to putting it in even more compelling terms. So I just want to say a couple of things quickly. One is, I very much like this sort of point you make that not all transparency is transparency. It has to be intelligible, which does fit into Kathleen's point also about, you know, which I've often thought also, is why is the administration, why are administrations often so reluctant to actually share their legal opinions? And often, you know, it seems, now, Libya is also a bad example. I mean, I'm not sure there ever was a written legal opinion that would stand up to very much. There was a white paper, Harold Coe sort of testified in almost identical terms to the white paper. It was basically a 2-paragraph, this is what we think with all of those factors. But I agree that, you know, transparency on that order would help. The one thing, so you, and I was trying to avoid this partly for obvious reasons that have nothing to do with good character. I was trying to avoid the Affordable Care Act, in part just because of its complexity, but also because those examples don't quite fit what I'm talking about. There's no, you know, President Obama, nobody's arguing that the president has inherent authority over healthcare or over the, you know, insurance subsidies. And so the idea of, you know, what I think you're really talking about is what I feel we're talking about there is really the larger question about the appropriate role of dynamic statutory interpretation in the administrative state generally, and that's a great and important question. But an example in my mind that would fit more you're raising this sort of self-help question, where Congress might be intruding, but the administration doesn't want to quite say that, has to do with the National Defense Authorization Act and its interpretation, so stretching quotes there, when it came to exchanging Guantanamo detainees for Bo Bergdahl. Because so that was an example where, again, the administration offered a statutory defense, even though ironically the Bush administration had, in one of the OLC opinions, it had withdrawn, had spelled out this is absolutely within the president's constitutional power to do whatever with prisoners of war he wants to do. But so that might be a better example of what you were talking about. I am talking about, and because of this, because I'm talking about areas where the president does have a non-laughable Article 2 basis for arguing if they chose to go in that direction, I think we typically are talking about contexts in which judicial review will not be available.
Right.
And so what I'm really talking about is kind of the process of internal law generation of almost the kind of Jerry Shaw sort, where the executive branch is generating its own internal law of constraint through these conventional professional, cultural behaviors.
Yeah.
But you know, I very much appreciated the response.
I'll just say very, very briefly to that, that I don't think the ACA need fall out of your story, because on a certain understanding of the separation of powers and the take care clause alluded to by Hal last night, there is a constitutional foundation to all of these interpretive moves. So I think the argument would look something like on what your book notes is most associated with Lincoln in a war powers context, but could be generalized on an adequacy theory of what faithful execution of the laws requires. The president does have a constitutional duty, or at least an option, to see to it that statutory schemes are realized in some adequate way, and it actually is constitutionally problematic to let a statute like the ACA collapse under its own weight. So I think that's what the argument would look like. One could rebut that, but you would say that even though there's not a commander-in-chief basis for fixing the ACA in the various ways that has happened. There may actually be a faithful execution basis because on this understanding, again controversial, you have to stretch to realize a greater take care and therefore constitutional value, which is coherence and workability of statutory schemes.
I'm wondering whether the students in the room in particular know what the issue is with the Affordable Care Act. Do you know? Because I happened to hear a presentation by Jonathan Turley about a month ago, who was representing the House of Representatives and suing, trying to get the Affordable Care Act struck down. So that's where I learned it, but I'm not sure whether you would have learned what it is. So I'm wondering whether.
Oh, okay, so let me say briefly then, I said, thank you. There's a lot of complexity there, but in short, the Obama administration has, through numerous administrative actions, interpreted the ACA in ways that a lot of people have found to be a stretch. Some of that includes, and a lot of this follows from the fact that Congress has not been willing to update the ACA, which is politically toxic, as I'm sure you do know. So that includes delaying the effective implementation date of some of the mandates on employers. It includes allowing the federal government to create exchanges on states that weren't willing to do so, it having been previously anticipated that all states would be willing to do so, and numerous other moves that I think vary in their textual aggressiveness, but the Obama administration would say are all in the service of allowing the statute to function as it was intended. And this was litigated in the King versus Burwell case that the court decided last term on the issue of the state exchanges, where the court sided with the administration. That gives a flavor to it.
But the Turley issue actually is not, if I understand, it's not the interpretation of the ACA, the interpretation of the appropriation statute, and whether or not they're taking money for subsidizing the insurers out of an account from which Congress has actually given its permission to take money.
And let me just say, this illustrates your point about density. I kind of need a PowerPoint to go through it, right? Which gives you an idea of how dense it is. So it may not have resonance with the public at large. It clearly has resonance with some segment of the public, right? But it may also have some resonance with the district court judge who refused to dismiss the case and is allowing it to go forward.
Yeah.
So it's sort of a nice illustration of the point you made, I
Yeah,
think.
that's right.
Questions, comments, please?
Good. Well, I really enjoyed the panel. Sorry I came a few minutes late. So sort of 2 points and a question, I guess. One is sympathetic to your project, Peter. You know, I was taken aback when I heard, oh, you're defending this practice, but you've actually given me food for thought, as your work usually does. And I do like your point about the phenomenon of internalizing rule of law principles and the act of internalizing statute. That exercise is valuable. And I might suggest a CF site for you drawn from International Human Rights Scholarship, which is the work of Ryan Goodman, Derek Jinks, to a lesser extent Una Hathaway, which is, you know, why do human rights treaties matter, especially when they're not justiciable, you know, for the most part in most states, etc. It is the notion that some segment of every government, once they sign on to these things, has to at least take them seriously or pretend to take them seriously and deal with them and write reports and etc. And that actually does have some moderating effect, even in, you know, somewhat authoritarian regimes. So that's what I'm sympathetic to. That said, let me give a pushback and then unrelated question. The pushback is my recollection of at least a lot of the Bush administration briefs in the 9/11 cases wasn't naked Article 2 arguments alone. The briefs were basically actually, they were much like John Yu's torture memos. They were first, here's the statutory argument, which, you know, is to a greater or lesser degree a stretch, and here then is the solo Article 2 argument. And my concern there is, you know, that is kind of very commonsensical lawyering, which is, okay, here we have a problematic stretch read of a statute, But this is a lot safer court or public than our even more outlandish Article 2 argument. And so it renders the statutory argument, much more plausible or seemingly plausible even when it's not. And so, the result is the same. Now, it didn't work in a lot of those cases when it got to the Supreme Court, but it didn't work by one vote, right? So I'm worried about that dynamic because I really don't see a lot of, or hadn't seen a lot of Article 2 solo arguments. And so I think when you put in the statutory stretch argument, it might have that unfortunate dynamic. The question is just very quick, which is, what about treaty stretches? And is there more room for stretches in administration arguments concerning treaty interpretation? Now, the administration or any executive is going to say, well, because it's foreign relations, we should get even more, latitude when we interpret treaties. Now, I disagree with that, but, what would you say about that?
Well, what I would say about that is I've never thought of that question. And I'm trying, I guess I would want to think about it a little bit, just to think if I can imagine a kind of analogous situation. Well, I guess, in the post 9/11 litigation, I mean, there were disputes about whether the Geneva Conventions and the Common Article should be interpreted a certain way that would exclude the Taliban or people associated with Al-Qaeda from its coverage.
And that was also a John Hugh outlandish, idiosyncratic,
Right.
Argument that 4 justices bought.
Right, and you can say that, and in the backdrop of that was, again, the sort of Article 2 thing. I guess I want to say 2 things. And one is, there are always, I think, important analogies or important lessons to be learned from public international law and separation of powers law, because customary law, plays such a strong role in both of them. So again, one of the things that Hal mentioned last night is interpretation is largely driven by, he mentioned 5 factors, and one of them is, one sort of experience. And I do think it's not an accident that, to the extent that we have a shared perspective, that perspective in part reflects that we were part of government at the post-Watergate moment. When attorneys general from both parties, Ed Levy, Griffin Bell, and Ben Civiletti, were deeply dedicated to the idea of reprofessionalizing the Department of Justice and not being politicized in the way it had been under the Nixon administration. And so I think we both witnessed and saw repeated examples of lawyers saying no. We were I don't think either of us was actually part of the team that was doing counseling on what to do in response to the seizure of the hostages in Tehran. But certainly, I think we had secondhand knowledge that a lot of retaliatory steps involving Iranian nationals in the United States were being mooted, that our superiors were having to say, no, that's not going to happen. So I think that led us to believe that these almost intangible features of organizational psychology do loom large in the behavior of the political institution. To be honest, I haven't been in government except as an occasional consultant, for the last 35 years. Whether it's still so is, Jack Goldsmith tells me it's still true. I trust him. So, one hopes. The thing that's hard is, it's hard to distinguish, I think, and this is an anxiety I had in my own argument, is sure, as you say, any lawyer is going to make a statutory argument before you make a constitutional argument for obvious strategic reasons. But, it's often hard, and maybe a critic of my paper would say it's impossible to distinguish between administrations that are, purporting to hold Article 2 back because they sincerely don't want to make that claim. They think it would be, bad for the country to make that claim, and they are really prepared to make the statutory argument and live with the results if Congress decides to hit back. Versus administrations that say, oh yes, torture only means the kind of pain you feel when your lungs are ripped out. And by the way, if that isn't what torture means, it's unconstitutional. But I am sort of drawing on that distinction. And it's funny because when Dave started by talking about the greater sincerity of the Bush administration lawyers who surely believed what they were saying, I was reminded of a history professor of mine who said to our class in the context of some historical lesson, remember, there is no virtue cheaper than sincerity. But I want to say there is a difference between when an administration is sincerely willing to take the risk of offering its statutory reading as being its defense, and when it's just cover for what it really thinks, which is Article 2 lets us do this.
To say real quickly that, yeah, the relationship of sincerity to rule of law is a big, fascinating topic. But I think the challenge, it's a great point, because the challenge of the question is that the paper implicitly assumes either that there's substitutes, the stretch or the naked Article 2 argument, when in fact they may be synergistic. On the treaty point, I just want to say, I think stretching would probably, in my view, and if this flows from your analysis, be more acceptable in bilateral treaty situations, because there the normal effects of reciprocity would kick in versus multilateral treaties, because the concern with stretching in the domestic context is that there may be an asymmetric relationship between the executive and Congress in the balance of powers. In treaties, I think the executive branch is more likely to internalize the fallout from bad interpretations of the treaty, at least in bilateral situations.
Thank you. I had comments which might also hopefully invoke responses for both Kathleen and Peter and perhaps David. First, in relation to the whistleblower and reframing the whistleblower through this sort of lens of the role they play in the constitutional conversation between the executive and the parliament. From an Australian perspective, this is sort of not a surprising way of framing whistleblower protection, and we have a Public Interest Disclosure Act at the federal level rather than Whistleblower Protection Act. But I just wondered whether it's also really important to not lose the framing of the individual rights and the protection that affords, because this is an actor coming into that conversation who's an individual. And in Australia, we don't have a Bill of Rights. And so those protections are not as strong, and we have serious prosecutions of whistleblowers. And so I think that I would be worried if the focus moved too much to being an institutional actor and lost that distinct characteristic that the whistleblowers, perhaps also media, might have, and so the importance of framing it in both through both lenses. And my second comment was in relation to the statutory stretch, because as I was listening to Peter, I was thinking, oh, I've seen this before in Australia, and I'm sure you've seen it over here with your Supreme Court, in another separation of powers context. And that's when in Australia, the High Court has considered the constitutional validity of statutes that entrench or have incursions onto the judicial process. Are these statutes have such huge incursions onto the judicial process that we have to strike them down as unconstitutional, or can we reread them and stretch them in a way that we can import judicial process and judicial discretion into them? In Australia, the High Court has done that really controversially. There have been statutory interpretations that have been adopted that, up until the High Court, and these cases went through the District Court, the Supreme Court, the Court of Appeal, best constitutional lawyers working on them. No one had thought of the interpretations that the High Court managed to find in these statutes, because the court didn't want to strike the statute down and rely on that constitutional power, but instead they stretched the process that was given. So I just wondered whether there was anything of use for you in looking at statutory stretches by the third institution in separation of powers when it's looking at its own powers vis-a-vis the legislation.
So I'm trying to, it's not as if there have been no disputes that have reached our Supreme Court over statutes that had an impact on judicial power. And actually, the post-9/11 litigation is sort of an interesting example of that, because first the court speaks its mind, and Congress says, we don't want you to speak your mind. And they say, oh, but you didn't mean that retroactively, this case was already filed. So they say, we don't want you to speak your mind, and this is retroactive. And they say, oh, but that would be suspending habeas corpus, you can't do that. So I don't think, my understanding of law anywhere in the Commonwealth is pretty sketchy. But I have the sense that, and I understand, obviously, the constitutional situation in Australia is not the same as the UK, which doesn't have a written constitution at all. But my sense is that your courts may have more comfort or creativity in developing sort of substantive canons of construction that allow them to pull non-intuitive meanings out of statutes. And so, in the case book, we occasionally have raised this question. So, if a statute allows an administrative agency to make a decision that would potentially affect foreign policy, even though it's a decision entirely within the realm of foreign commerce, which is within Congress's explicit authority to regulate, should there be a substantive canon that says that that statute should always be read to give the president a kind of implicit veto power? If the Nuclear Regulatory Commission licenses something that we wouldn't want some other country to do because it would violate what we take to be appropriate non-proliferation norms, can the president actually instruct the agency not to do that? We don't purport to answer this. But one way, I guess, around is a new toolkit for statutory stretches would be inventing a bunch of substantive canons that would give the president a way of saying, I'm not claiming Article 2 because I'm invoking the generosity to the executive and foreign affairs canon. I'm invoking the, of course you don't have to tell us this secret canon. I'm not sure how far I would be eager for us to go in that regard, although, it might improve intelligibility.
Can I just respond? One place to look for that kind of dynamic is actually on the state level, state Supreme Courts asserting their exclusive ability to regulate the legal profession. And so I'm not sure that, I don't know how much your question resonates in the certainly in the national security sector, but in the sector of who gets to regulate the legal profession, I think that might be a place where we would see that dynamic happening, where the state Supreme Court looks askance at, but sometimes allows a legislative enactment of general application to apply to lawyers on debt collection, for example, but other times, it doesn't. And so that would be a good place to look for that dynamic, I think.
Helen?
Oh, sorry,
Thanks, Professor Bruff. Professor Posen, one of the factors you listed was congressional approval or acquiescence of a president's statutory stretch. How can there be congressional acquiescence without one of Professor Clark's whistleblowers? And then my second question would be, if there is a whistleblower, can that congressional approval be implicit with Congress taking no action, or must it be explicit with some form of congressional ratification of the president's interpretation?
Yeah, they're deep questions. There need not be a whistleblower, I think, in normal circumstances. I think most of the stretches Peter has in mind are not operating without congressional knowledge. And so, as with the Affordable Care Act or the Deferred Action Immigration Programs or War Powers in Libya, there has been knowledge in Congress. Okay, so that threshold is clear, but there's still your second question about how can Congress meaningfully manifest its acquiescence or approval without a whole new statute blessing what the president's done, in which case the whole question isn't even that interesting anyway, because obviously we're, at least at that time going forward, comfortable with what's happening. So there's a pretty big debate about this in the separation of powers literature, and the basic concern, which I think you're intuiting, is the executive branch is happy to claim acquiescence in even the most pitiful gestures of non-outrage. So some sympathetic senator or committee chair here or there made some nice noises about what we did, and therefore it's okay. And to which the rebuttal is powerful, which is that it's unrealistic and unfair to expect Congress to gin up a whole new statute or to have a unanimous expression of disapproval, especially in our partisan age. So we should accept, I think, lesser noises of dissent as non-acquiescence. So let me just use the example of Libya to make this a little more clear quickly. One interesting feature of that Harold Coe testimony you were referring to, laying out the factors why this was not hostilities and why that's an acceptable way to think about the statute, was a footnote in the testimony that said, and by the way, you, Congress, told us this was okay, because 60 days is when the clock runs out, and when you're in violation of the statute, if you're still doing the things you've been doing and they amount to hostilities. And the footnote says, after day 60, we have on record House Speaker John Boehner from the other political party, and also John Kerry and a bunch of powerful leaders in the Senate and the House saying we see no violation of the War Powers Resolution here, which must mean you are not in hostilities because more than 60 days have passed. And that's probably because Congress, they didn't want to deal with the issue, they have their own incentives. But so that was a claim of a kind of acquiescence. At that time, I don't think that was a crazy argument as buttressing the statute interpretation. However, after that point, after the testimony, Congress manifested more anger at the interpretation of the War Powers Resolution. A resolution got out of the Senate Foreign Relations Committee that said, you are in hostilities. That is our committee's official view. There was a bipartisan vote on that. So at that point, I think the analysis flips. I'll leave it at that.
Thank you for your patience. I'm gonna give Hal the last word. Is that okay?
Okay. You're there to respond to it.
My eye is on the clock as well. I won't impede the break much longer. Since my thanks are essentially limitless, I think I'll stop expressing them in here because it would take all our time. I thought I'd go to a system of baseball signals. If I tug on my right ear, I'm feeling thankful again. If I'm not feeling thankful, I'll express it the way my students do by simply falling asleep. What struck me about the three of you in your presentations was you were all working around the theme of the felt tension between law and expedience that all good lawyers feel, and that whistleblowers feel profoundly. I feel a moral impulse to tell the world about this, but I know I'm not supposed to, etc. For the lawyers, I think, and I'm thinking in terms of the statutory stretch, the felt tension there is very productive because you're not sure how far you're willing to go and you don't want to do it much. The danger, I think, is when you don't feel the tension. I'm thinking of the loss of Robert Jackson's detachment. And at the start of the Bush administration, one of the first things that Alberto Gonzales said to the White House counsel was, we are going to be forward-leaning in here. And so everybody, like John Yoo, thought they were part of the team rather than detached professionals looking for limits, although sympathetically. So I think the statutory stretch is very much a part of the everyday lives of good lawyers, and ought to be.
Thanks, everybody. We're gonna take a short break and let's